Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers, with Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Good morning and welcome to Law Power Hour. I had a chance to listen to Dr. Holly this morning. He was apologetic at the end, but he was telling you all the truth, that we've got to work together to get things done. Otherwise, if we sit on our hands, nothing gets done. And that's important for you to keep in mind in my show today. I'm not in the business of lecturing people or telling people, you got to do this, you got to do that, but there's a formula that you have to follow for success, and part of it involves perseverance, determination, dedication, and the initiative. It applies to everything, and the subject matter of today is something that is very, very important. It's Social Security disability. It's Social Security disability. There are two parts. There's those who have wage earning accounts and those who are drawing supplemental insurance benefits who don't have wage earning accounts. Now, in order to make a claim to receive these benefits, you must have perseverance. You must follow through. It requires actual commitment or family commitment. And I use the word family commitment because not everybody is physically or mentally capable of following through on their Social Security disability case. The reason that I brought this topic up today is that it's very, very important to understand what it takes to qualify for Social Security disability and how long it takes to process a case. The normal turnaround time from the filing of an application for Social Security disability to the date of a formal hearing where you appear in front of an administrative law judge is 491 days. That's 1 year and 4 months from the time that you submit your application. Good morning.
Good morning, Mr. Keller. I may be getting ahead of your subject, but I have a question. I have a grandson. He has a disease called Kawasaki syndrome. He was on disability. Now, it's a heart thing and it's a lifelong thing. Will he be entitled to get disability?
Yes, and let me explain to you. That's a very good question because I'm familiar with the disease. It's a genetic disorder.
Exactly.
Okay. And it doesn't get better, it gets worse as time goes on.
Oh, don't tell me.
Well, I have to be honest with you. I have 2 clients that have the condition right now, and it can cause migraine headaches and can cause all kinds of other things. But I'm not a doctor, so I'm not going to pretend to tell you everything about the disease. But I'm going to explain to you the process. How old is your grandson?
He just turned 7.
Okay. Now, he has to go down, or his parent has to go down and apply for SSI benefits. That's Supplemental Security Income Benefits. And he may meet a listing, and I'll explain it to you. In each part of the body, you want to stay on the air so you can ask me questions, or do you want to be off the air? However you want.
I'll stay on the air. My name is Sullivan.
Okay. In each part of the body, there are listings. For example, when you have a heart condition, if you go on and Google Social Security listings and you look up heart conditions, it talks about genetic heart conditions, it talks about valve conditions, it talks about ejection fraction. In other words, how your heart functions. And it's a combination of these factors in the listing that qualify an individual to receive benefits. The same would apply to your vision, your breathing, your limbs, your back, arthritis. There are listings for all of these, and there are listings for mental impairments. So your grandson may have a combination of impairments. And the reason why it would be easier for your grandson to get benefits, because if he has a heart condition and he goes to school and he's delayed in his education,
Right.
you would see, I know what I'm talking about. You take the results of the IEP, those are those evaluations conducted at school, and you use that information along with his medical condition to prove that he can't function or she can't function in a normal classroom environment. They can't interact with children. They can't play with their friends at school because they're limited. And all of those factors will qualify the individual for disability. Now, in order to do this, you don't need a lawyer, but you're further ahead by having a consultation with a lawyer to tell you how to do it and what you have to bring forward. So you can call me. I'll give you my number. It's 248.
I have your number. I'm going to have my daughter call because he was receiving it, but his mother worked. So he wasn't getting a full amount, but he was getting something. But now they're trying to remove him. They're saying he don't need it anymore.
Well, if his mother works, he doesn't get the full amount because they use an economic test in the family. But there are other factors to consider. And we can go through these other factors with his mother, and he can receive the benefit. Now, if he was receiving the benefit, and this is very important for all of you listeners to understand, if you're receiving a benefit as a child or you're receiving a benefit as an adult, and they terminate or they tell you you're going to terminate your benefits, you have 60 days to appeal the decision, and you can request that you continue to receive benefits while the appeal is pending. It's a very, very important part of the process. There's a rule that requires you to indicate on the form when you appeal that you want to continue your benefits while the appeal is pending. And that means all the way through the appeal process. That means if you go to a formal hearing, and after the formal hearing, if you have to appeal it to the appeals council and go to federal court, you could be tied up in this claim for 2 years and continue to receive benefits. And I do have an important fact to share with you. You know,
Okay, I'm going to have her call you.
Okay. You know those people who advertise Social Security on TV all the time, call me, we'll handle your Social Security disability case. They don't go to federal court. They don't follow through and go the last leg of the process. They don't go to the appeals council with it. After a formal hearing, they don't go any further. So you should make sure when you contact a lawyer that you have a clear understanding of how far your lawyer is going to take your case. In my office, we take them all the way to federal court. And that's not an easy task. That requires a commitment with the client for 2 years. And we may refile another claim while we're in federal court at the Social Security office with a new onset date, because things change, facts change. We're going to talk about that. We'll start at the very beginning here. When you apply for Social Security disability benefits, you go down to the Social Security office and they're going to ask you, when did the problem start? And this will be the onset date. Well, if you're applying for Social Security disability and you've worked 5 out of the last 10 years, that's 20 out of 40 quarters, that's the first test, and you give them a date, for example, let's say you say January 1st, 2017 is the date that I became disabled. That may not be the actual date that you became disabled, because that may be the date that you could no longer work and perform your job, but that doesn't necessarily mean that you couldn't perform another job, and that's what Social Security is going to look at. So let's unravel the Social Security process before we make a determination as to the onset date. And here's how we unravel it. Social Security requires, if you're applying for Social Security disability, that you work 20 out of the last 40 quarters. That's 5 out of 10 years. And that you have a disability that has lasted or can be expected to last 12 months. Let's stop there for a second and define this. If you have terminal cancer, it's going to last more than 12 months. If you're a diabetic and you're on dialysis, it's going to last more than 12 months. You may be entitled to receive an accelerated benefit claim for Social Security disability. But in order to reach that level, there's a few things that you have to do. If you call my office, 248-335-9266, we will tell you how to process that accelerated claim. It's not difficult. When you go down and apply for benefits, you just bring in a letter from the doctor saying that your condition will result in organ damage. Now, you just can't bring in a letter from any doctor. It's got to be your treating physician. And if you're on dialysis, certainly your kidney specialist or your internal medicine specialist can write that letter, state that you're on dialysis permanently, and that will be a basis for qualifying you. So people are going to say, well, how can you qualify that quickly? Well, it's simple. You have to have a disability that has lasted or can be expected to last for 12 months. That's number one. Number two, you must be incapable. You must be incapable of performing substantial gainful activity. That means that you can't hold a job. That means that you can't work full time. Now, full time is more than 25 hours a week for Social Security purposes. However, if you're on dialysis, and I'm only using dialysis as an example because it doesn't require a lot of extra effort to figure this out, you've got to go to the clinic at least twice a week for treatment, unless you have it at home. So if you're going to a clinic for your dialysis at least twice a week, you're not going to be at work. And if you're not at work, you can't perform substantial gainful activity. Therein lies the issue. If you're suffering with a back injury and you're required to go for treatment once a week because you have a disc problem or a pinched nerve, and you can't perform services because you're going once a week, and that's for a whole year, obviously you can't perform substantial gainful activity. So you have to have a disability that's going to last at least a year or longer. It's going to prevent you from performing substantial gainful activity. If you get through those two criteria, that you must have a severe impairment. Now, what is a severe impairment? It can be physical or it can be emotional. If it's physical, it must be documented. And in order to be documented, you must have objective evidence of disability. What is objective evidence of disability? Diagnostic tests that support your claim. And if you say, well, I don't have any diagnostic tests and I can't afford them, and you're receiving Medicare, I hear advertisements every weekend for these diagnostic centers. I'm not going to advertise the centers that would permit you to have diagnostic tests for your neck or your back or your legs with MRIs or CAT scans. You take that to your doctor, and you get your doctor to support your claim. And then your doctor has to write a letter explaining why you can't engage in substantial gainful activity. One of the biggest problems that we have in Social Security and SSI cases today is the lack of cooperation from the medical community. The medical community loves to treat, loves to write prescriptions, loves to send you out for diagnostic tests. But when it comes to the most critical part in assisting a sick individual in getting their disability benefits, 90% of the medical community falls short of the mark. They won't fill out a questionnaire unless they get paid for it. They won't turn over medical records unless they get paid for it. They won't cooperate unless you go that extra mile. And sometimes these doctors can charge as much as $500. Can you imagine that? As much as $500 to provide the information to support a claim. So when I say that you have to be vigilant and persistent, you have to get a relationship with your treating doctor, not some hired doctor, but a treating doctor who treats you regularly, and your doctor has to cooperate and assist you in receiving your benefits. So once you have objective evidence, and objective evidence is important because it applies not only to those people applying for Social Security disability, but those people who are drawing disability from work and who are required to apply for Social Security disability benefits. Any major corporation in the United States, whether it's IBM, Ford, Chrysler, Amazon, any one of them has disability, Walmart, it doesn't matter, has disability coverage for their employees. If they have short-term and long-term disability, on long-term disability benefits, you're required to apply for Social Security disability after you're off for 6 months. And in order to qualify for the long-term disability, you have to prove that you can't do your job or any other job. If you prove that you can't do your job or any other job, you're halfway home for Social Security. But I have cases in the office right now where people are receiving Social Security disability and their long-term disability carrier has denied them because they say there's other work that they can perform. So you need to contact a disability specialist to resolve these issues. You can call our office, 248-335-9266, and we can help unravel this mess for you. If you apply for automobile no-fault benefits and you're receiving wage loss benefits and you're off more than a year, under the no-fault law in the state of Michigan, you are required to apply for Social Security disability benefits. And in order to get Social Security disability benefits, you must prove that you have objective evidence of disability and you cannot engage in substantial gainful activity, and that your disability is going to last more than 12 months. Well, at this point you say, oh, it sounds pretty simple, but it isn't. Because Social Security has a number of tests that they look at. First of all, they look at the type of work that you performed. Is it skilled work or unskilled work? They look at your education. Are you a high school graduate? If you're beyond a high school graduate, they take that into consideration. College graduate are beyond college. So it's not as easy as it sounds, because all of these are factors that weigh in your right to receive disability. I'll give you a thumbnail sketch which will help you understand the problem. You graduated high school. You're 44 years of age. You have a ruptured disc in your back. You've got pain radiating down your leg. You have a fusion. Your employer won't let you go back to work because you can't do the job, and they have no other work available for you. It may or may not be a work-related condition, because the ruptured disc may be the result of arthritic changes in your spine, which would maybe preclude you from receiving workers' compensation. So you apply for Social Security disability. Now remember, I said you're in your 40s. You're going to have a very difficult time getting Social Security disability benefits. You say, well, why? I'm disabled. I can't work. Because age and education and work history and skill level and transferable skills are all important factors. And here's how it goes. You're younger until you get to age 50 for Social Security purposes. So younger people theoretically are capable of performing other work easier than people who are 50 to 55, which is closely approaching advanced age. And then older individuals, according to the Social Security guidelines, 55 and older, up to age 66, can qualify for Social Security disability. Well, as you get older, it's easier to apply because there's less opportunity for other work that you can perform. So here's what happens. So you apply for Social Security disability. You go down to Social Security disability office and you fill out the forms. Then you get an initial denial within 60 to 90 days. And then you've got to file a request for review. When you file a request for review, as a general proposition, you are going to get turned down on the request for review if you're under the age of 55. Over the age of 55, you may get turned down unless you've got really concrete medical evidence to support your disability. Okay, so you've gone through step 1 and step 2. And while this is going on, the state agency is having doctors. They're having their doctors evaluate your case, make a determination as to whether you're entitled to benefits. Well, you're not getting copies of this evaluation. You're just getting a notice that you were turned down because the doctor says you can work. You don't know what kind of doctors evaluated your case, but they're there. They're getting paid by the state agency to do it. So how do you combat this? You need to bring in documented medical records and reports and statements. You know, Social Security will say, well, what medical records do you have? So you turn in all the medical records. But medical records are no substitute. And this is really important. And if you're listening, call me right now if you have a question about this. Just submitting medical records to the Social Security Administration is not going to do the trick. Good morning.
Good morning. I have a question for you. I was in an accident when I was 45 and I went out on disability. It went into long-term disability, and then I had to apply, as you said, for Social Security disability, which they told me I didn't qualify until I was at least 50, so I had to wait till I was 50. So I was fortunate enough that my company had the short and long-term disability. Now, I want to ask the question, now I'm at the age that I can get my pension, but long-term disability say I have to tell them. And what are the rules for that? And I'll listen offline.
Well, here's what you're going to have to do. You're going to have to give me a copy of your long-term disability to look at to make a determination as to whether you should stay on long-term disability or you should apply for your pension. And here's why you need to do that. It's really important. I don't know where you work, but sometimes if you're on long-term disability, you can get credited service towards your pension even though you're on long-term disability. And you don't have to go in for the pension if it's not the right time, because you could get shorted on your pension. For example, if you work for the big three and you have a UAW contract and you're on long-term disability, and you don't apply for disability pension, and you got hurt at work, you'd get credited service for the entire time that you were off. Otherwise, you may not get credited service for it. You just have to have somebody sit down, take a half an hour, bring in your pension papers, review it, and we'll give you the best solution as to what you should do. Call me at 248-335-9266. Now, I'm not doing this because I need another client. I'm doing it because I want to make sure you make the right decision. It's more about decision making than it is about making a new client. It's very important if you're drawing long-term disability that you make the right decision. Because if you've been off more than 5 years, you may not have credited years if you're applying for Social Security disability. So it can be kind of tricky. I just went through this for a man who was working at General Motors, and he had a special insurance contract. Well, they wanted him to retire. If he retired, that stopped his long-term disability benefit, and his long-term disability benefit, because he didn't have Social Security, was more valuable to him than his pension, because he wouldn't get all the supplements that he would otherwise receive. So, give you an answer on the air, I can only give you a general one. Giving you a specific answer, I can look at it. I can tell you by reading the contract what you should do and how to handle the claim. Because you could lose a lot of valuable benefits that way. Now, getting back to what we were talking about, and thank you for calling, by the way. Getting back to what we were talking about. So you're age 47. You're close to age 50, but not close enough to make a difference. If you're 49 and a half, though, they'll treat you as if you're closely approaching advanced age if you're going to be 50 within 6 months. Now, this is a very important factor because they use a grid in Social Security. And what a grid is, it's a computer grid where they plug in information about you. Age, education, work history, skilled, unskilled, disability, whether you can return back to your prior work or perform other work at another level. And the reason why this is important is their presumptions. If you can't do the work that you did before, for example, and I'm giving you the practical side of this. If you have an arthritic condition, and your arthritic condition is so severe that you can't perform your past work, or if you're a diabetic and you get sick every week and you can't show up to work regularly, or you have high blood pressure and you have problems with your high blood pressure and you can't work regularly, you need objective evidence to support that. And that requires a relationship with your treating doctor or a specialist and your treating doctor to state that you need to be off work. You may need to rest 2 hours a day. Well, if you have to work 8 hours a day and you have to rest 2 hours a day, you can't perform substantial gainful activity. Or if you're on medication and the medication prevents you from doing your work because it makes you tired, it makes you groggy, or it causes you to have to frequent the restroom. It disrupts the normal work schedule. but you need documentation. You just can't go in and say, you know, I take a diuretic because I have high blood pressure. Good morning.
Oh, good morning. Happy Saturday to you. I would like to know if the no-fault insurance with the catastrophic fund is a competition against Social Security. A state senator told me once that there are only 8 people within the city of Detroit receiving money from the catastrophic fund.
That's not true.
Ah, okay.
That's
Is there
not.
a way to find out how many in Detroit?
Why, sure, you can call the catastrophic fund and ask the catastrophic fund.
Okay.
Do you know how
Now
the catastrophic fund works?
It works?
Do you know how the catastrophic fund works?
No, that's why I'm calling
Okay, well, here, I'll explain it to you.
you. Okay.
Okay. Now, I'm not going to give you the limit to get to the catastrophic fund because I have to be honest with you. I can't remember if it's 350,000 now or more. But this is how it works. When you get to the catastrophic fund limit, that means where your insurance company has paid out X number of dollars on your claim. And let's just say, hypothetically, since I don't know the exact number, it's $350,000. When you go over the $350,000, the insurance company has to submit your claim to the catastrophic fund for reimbursement. See me pull my hand back for reimbursement? So the insurance company gets reimbursed from the catastrophic fund. I can guarantee you that there are a number of people in the city of Detroit and Wayne County that have claims where the benefits have exceeded $350,000. I can say that without batting an eyelash, that there are people who've been involved in very serious accidents, have multiple medical problems related to the accident where the payments have increased beyond that. I know in my own firm, on the injury claims that we handle, in the last 10 years in the city of Detroit alone, that we have at least 10 people that have gone over the catastrophic limit. Now, what they're trying to do is they're trying to change that catastrophic fund because they're trying to revamp the no-fault law.
Right.
Well, there's a lot of things about the no-fault law that have to change. And you're going to be shocked when I tell you, one of the things that has to change is on first-party benefits. You know those benefits that you're entitled to receive if you're injured?
Right.
You know, for wage loss, for attendant care, for medical services,
Right.
for replacement services in the house. You know what's got to change there?
What?
They've got to change the attorney fee on that. They've got to reduce the attorney fee so the people get the benefits that they're entitled to receive. If they reduce the attorney fee in that area and gave more benefits to the claimants who were injured, that would help part of the process. Then there wouldn't be such a proliferation, such a flowering, such a reason to delay payment, because that's what a lot of attorneys do. They take the claim and they'll delay it for 3 or 4 months. It's scandalous. I just had a lady involved in a rollover accident where the attorney didn't do anything for the first 4 months because he was trying to build up the amount of money that she was going to receive so he'd get his attorney fee, which is ridiculous.
A third.
Well, yeah, you know what I did? I handled that claim for free for the lady and gave her the money because I didn't think it was right. It's not right to do that to people who are injured. The purpose of the no-fault law was to protect the public.
Right.
Not fatten everybody else at the expense of the public whether it's limousine drivers driving people to the doctor, whether it's clinics, whether it's attorneys, whether it's doctors.
Mm-hmm.
That wasn't the purpose of the law when we passed it. I sat on that committee in 1974 when they passed it.
Mm-hmm.
The purpose is to help disabled people.
Now, with the medical fees, they continue to escalate. And is there any movement to reduce that?
Yeah, that's part of the process. You see,
Okay.
if we draw a line, and I know sometimes y'all think I'm a little out there and a little far-fetched in my thinking, but I'm forward-thinking. It's not far-fetched, it's forward-thinking. Over here, we've got the laws of the state of Michigan related to workers' compensation.
Mm-hmm.
Workers' compensation, they have a schedule of fees. A schedule of fees as to what they pay. And this is how it's established. They look at what's common, and I'm only going to use the word common. It's a little more complicated than it. Common and prevailing.
Mm-hmm.
So if a doctor is getting $75 for a visit when you go to the office,
Yes.
and that's common and prevailing, and somebody's charging $150, according to the schedule, they can only get $75 because that is what is being paid.
Mm-hmm.
Now, some doctors won't take the case because they want to charge what they want to charge. That's perfectly fine. But you don't have to go there.
Mm-hmm.
So if it's a prevailing rate, then you get over here on the other side and you have a no-fault case and your attorney sends you out to one of their docs that they know, and he's a happy doc and he's going to run every test in the world on you, which you may or may not need. I'm not going to comment on that. They're going to hook you up with a limousine driver to take you there. They're going to, oh, you know what I'm talking about, don't
Yes.
you? Okay, then they're going to take you to you're going to get you a case manager, and God knows why you need a case manager. If you got a brain, you don't need a case manager. Then they're going to get somebody to clean your house and attendant care, and if you're really bad, they're going to put you up in a motel.
Mm.
We don't know who owns a motel, but the point is, when this is all said and done, there is no control on what the prevailing rate is. And that's why the catastrophic fund has trouble. That's why no fault has trouble. That's why we have trouble in getting people their benefits and getting them paid.
Mm. Okay.
And you see, the other problem is it's a racial imbalance, and here's the way it goes. They discriminate against people who live in the city and charge them more for insurance.
Yes.
Now, I'm going to tell you right now, my son lives in the city and goes to law school at U of D. He lives in the city. His insurance is 4 times higher because he lives in the city. But we can't cheat. We got to use his city address because that's where he lives. Now, we got to change this. But the way we have to change this is not to give out some funky benefit to people who live in the city, get rid of the catastrophic claims fund. We've got to make this more in line with a fee schedule for benefits. We've got to make this more in line with a percentage reduction on first-party attorney fees. Now, those for pain and suffering, a third, we've always had that in tort reform, and it should stay that way. It was that way before tort reform. I've been doing this for 51 years.
Mm-hmm.
What we have to do is we have to clean this up.
Right.
And the same thing in Social Security. That's why I say, you got a Social Security question, call me. I'll give you the answer. If you need a lawyer, I'll tell you you need a lawyer. I'll tell you what you have to do. But you got to get cooperation. Just like Dr. Holly was talking about this morning.
Mm-hmm.
If you don't have cooperation amongst people, it doesn't matter whether they're doctors or lawyers or clients, we're all people. We're not going to bridge the gaps and move forward together.
I agree. But I did want to know whether or not this no fault catastrophic fund competes against Social Security. Do people
No,
apply for one or the other, or both? Or
both. The catastrophic fund's got nothing to do with it.
the Social Security? That's what I wanted to know.
No, that's a bunch of hooey.
Mm-hmm.
The only benefit with the catastrophic fund would be if you were receiving Medicare, Medicaid, and you were going to catastrophic fund because part of your medical expenses may be paid by Medicare or Medicaid.
Mm.
But you got to understand something. If you're involved in an accident, and it's very important to know, and you're on Medicaid or Medicare, your attorney has to report to Medicare or Medicaid that you have a claim pending, regardless of whether you're at fault or not. So that means if you slip on ice in the supermarket parking lot and you make a claim against the supermarket, you still have to report the claim because you have to tell them whether you've recovered any monies. That's the law in this state, or you can have your benefits terminated
Okay.
or eliminated or suspended.
Mm. All right.
Okay?
Thank you very much.
You're welcome. Well, we spent some time getting through this, but it's important. Now we'll get back to the Social Security. I appreciate the calls today because it's an important issue. It's not a difficult issue. There's a formula for getting benefits. Because when you get down after the 491 days and you get to a hearing, if you've got your I's dotted, your T's crossed, your letters from your doctors, and what I was trying to point out before, the submission of medical reports without any doctor's interpretation, is a guaranteed cause for failure of your case. Good morning.
Yes, good morning. How long do you have if you fall in a place of business to make the claim? I know within 24 hours you go to the hospital, you still got to fill out an accident report. But before you file a lawsuit against them, how long do you have? I'm hang up and listen off the air.
Okay. Well, the question is, if you fall in a place of business, you've got to give the business notice that you fell there so that they have an opportunity to investigate it, and you always want to document it. So if you document it and you fall in a place of business, it gives you an opportunity to make a report. It gives the people an opportunity who own the business to evaluate the situation. A lot of places have cameras today. Yesterday, I had this most interesting call. My client was in a fast food restaurant. She claimed she slipped in grease on the floor. Fast food restaurant said, no, couldn't have occurred. Because your client was in flip-flops. I said, well, it was wintertime. I was in flip-flops. Well, they say they've got it on camera. So I have to go back to my client, call my client now and say, did this occur? Did this occur? They took her from the scene of the accident to the hospital by ambulance. So most of these businesses, just so you know, have two parts of the insurance contract. One is liability. That's they pay if they're at fault. And the other is medical. So even though you may not be able to make a claim for damages for pain and suffering, if there's no liability, no fault on the part of the premises owner, you may be able to make a claim for your medical expenses. And the way you make a claim for your medical expenses is that the deductibles, let's say that you've got Medicare or Medicaid, all your deductibles and your co-pays, you could turn into the insurance company, and the insurance company would make payment of the benefits. The insurance company would make payment of those co-pays. And you know, you get those bills. Always get those bills from the hospital. Even I get them when I go to the hospital and I've got to get a checkup or have a diagnostic test. Not all of those are paid for unless you've got gap coverage to take care of it. If you have gap coverage, the benefits are paid by your supplemental insurance. Otherwise, it comes out of your pocket. But the most important thing, first of all, is to give notice. And giving notice is letting them know when you're there what happened and making sure that somebody documents it. And that becomes the best way to report and handle the claim. If you do all that, you're in a better position to move forward. Now, if you'd like me to continue next week to talk about Social Security, I'm going to be off the air in a couple of minutes. Have somebody call in right now and tell me, and I'll finish this up next week, and we can move on to the next subject. Otherwise, I'll bring on a guest next week. I want to thank you for listening today, and hopefully we can continue on this journey. And I want to thank those of you who called in. I appreciate calls. If any of you want to call my office at 248-335-9266 and suggest another show, let me know. Good morning.
Yes, please continue.
Okay.
And thank you so much.
Okay, God bless you all.
All right, you too.
Okay, so we'll continue this journey next week, and I might bring on one of my assistants with me. I want you to be careful out there today because the weather's kind of strange. There's still some ice spots out there in the street and some ice spots in sidewalks, but it's going to be a nice day out. It's going to be warmer. I want you to go out and have a great day. Enjoy yourself. Thanks for listening.